The Full Melt Show is intended for a mature audience. It contains adult themes, adult content, and sometimes adult language. Listener discretion is advised.
The Full Melt.
Are you high? What are you talking about?
This is the Full Melt.
Give me a break.
The Full Melt Show. A marijuana discussion about news, culture, politics, and lifestyle. FullMelt.com. Toll free. 844-420-TALK. 844-420-TALK.
Hey, it's good to be back home, I'll tell you. Back home at the PetPain.com studios, broadcasting live with another full day of events in the medical marijuana arena, specifically today. Oh my goodness, there's so much stuff that happened today. We just got back from Chicago with the cannabis conference out there. It's CannaCon by My Compassion. What an awesome city Chicago is. What a great event. A whole lot of people out in Chicago heard about what's going on with medical marijuana there. It's been 2 years almost since they instituted medical marijuana in Illinois. In Michigan, it's been nearly 8. I mean, it's been a long stretch. And things have modified. Things have changed since 2008 in Michigan when they passed the Michigan Medical Marijuana Act by voter initiative. And then proceeded the stage setting for the play that took place over the next several years. Most of it, the court, through prosecutors and police, gutting much of the Medical Marijuana Act and the protections that it sought to put in place. Part of those protections are the Section 4 and Section 8 rights. Section 8 being affirmative defense, saying, hey, I did what you're accusing me of, but I have permission under the law, an immunity. And so I'm telling you that I'm pleading guilty of sorts, that I did this. It's an affirmative defense. I did this, yes. But there's permission. I have protection. And in order to get that protection, certain things have to happen. It doesn't just happen automatically. Now, something that does happen more automatically, given that you're, playing by all the rules, if you're a patient or a caregiver under the Act, are Section 4 protections. Now, this is a protection against arrest and prosecution. I'm getting all kinds of buzzes about this today. Turning that off. Now, this protection against arrest and prosecution is also very limited, the courts have defined. Through motions and briefs and guidance by the Attorney General, who hates the Medical Marijuana Act, they've pretty much made Swiss cheese of the protection that was put in place. And it's actually, instead of using it as a protection, as a barrier to charging somebody for a drug crime and giving them very harsh punishments as a result, they've used it, instead of that shield, as more of a sword. They actually targeted these people in Michigan who were growing marijuana for their own use or for that of other patients that were assigned to them in the program. They weren't really assigned. You make this relationship with a caregiver who has an ability to grow and some knowledge about growing and is providing medicine or producing medicine already. You have him grow your plants for you. It's a good system because this gives this individual control to somebody with knowledge and ability that can help steer you in the right direction as far as what varieties you need for your particular condition, right? It's not just, the growing part of it, but it's also the knowledge part of it. Many of these really good caregivers have been thrown to the wolves in the criminal justice system. Many of them been made into felons. Most of these cases not even proved in court. Most of these cases were pled out under threat of larger charging. Let me just tell you that if you intend to enjoy your rights, you must assert them. And that does not include waiving preliminary exams. That does not include, and I'm not a lawyer, but we're going to have a lawyer on to talk about this. I'm just telling you from my perspective, my humble non-lawyer point of view, and the great amount of knowledge that I've gained over this, past 10 years about this, specifically the last 6 or 7. This is something that is good because these patients and caregivers have a system in place, and if you're going to have your rights, you have to assert them. That means you can't plead guilty, and that's what you're going to have to do if you make a plea arrangement. Plea arrangements are good if you want to accept the conditions, but you are making a formal claim that I'm guilty of something. Many times, police and prosecutors will threaten you with much larger crimes or include other throw-ins and tack-ons that they just do as put on there as bargaining chips because they know they have no way of proving these individual separate charges. Like the main charge they came after you with, but then they threw in a gun charge, and then they threw an obstruction of justice charge, and they threw in a lying to police charge, and they throw all these other charges on there, and they say, look, we can make all of this part go away, including that felony gun charge, if you just plead guilty to the underlying growing charge. And many people want to play that gamble. They want to roll those dice and say, okay, I'll plead. I know I'm not guilty, but I don't have the money to defend all this stuff. I'm going to get some crappy attorney who doesn't have any real vested interest in helping me because he's a public defender and he's only going to get like $200 that you're going to have to pay back to the court later in Michigan. Despite the fact that you've already shown that you're indigent, have no money to pay for an attorney. This attorney, I'm telling you, in this system, has no vested interest in telling you what to do. He's just going to try and get you off of his plate. He's only getting a couple hundred, maybe $250 for anything that he does for you, including filing work and anything, spending time. These guys make that much in an hour under other circumstances. But the courts assigned this case as a part of their mandate. It's a part of what they got to do for their legal duties to being a lawyer. They are an officer of the court. So the court is assigning this case to a public defender who now his mind, rather than being set on defending you and representing you in your best interest, I'm telling you, the money incentive says no. What we'll do is we'll get this guy to plead out. We're going to waive the preliminary exam. I'm not going to spend any money on calling witnesses. I'm not going to make anybody prove anything. We're just going to get this guy to sign here that you're guilty of this, but we're going to make all this other stuff go away, and that's the deal. And you're going to pay that attorney a lot of money for that under normal circumstances. If you can't pay a public defender, you may be able to get another crappy attorney who also may see that you're limited in resources and funds, and he'll ask for a retainer, and then he'll spend that retainer quickly, and then when you don't have any more money, he'll run on you. This has been my experience just reporting. Now, look, I love my attorneys, and there are a lot of great attorneys. I'm not smearing the profession of attorneys at all. There are many, many great attorneys, but they cost money. And if you don't have the money to employ these people, your rights in the legal system are greatly diminished because you can't assert your rights. You don't know how to position yourself to navigate through those turnstiles. And if you intend to, get through that minefield unscathed, you would best employ the guys that know how to get through it. And if you don't have the money, you're going to get a public defender who's not going to get you through it. He's going to let you put your foot over part of a landmine, and it might hurt a little bit. I'm just saying that's the way the system works. Whether or not people intend it to be that way or not, that's what goes on in the long run. I think many attorneys will agree with me. But if you're going to be a patient or a caregiver in any medical marijuana system, you're going to have to put yourself at some level of risk because all marijuana use under federal law is currently illegal. And it's not just a little bit illegal on the scale of what's bad. A little bit illegal might be a Schedule 5 controlled substance that they could bust you for. A little bit less legal with Schedule 4. This is a Schedule 1. It's the top illegal substance list. It's at the top of the list. Nothing stronger than that. Nothing more dangerous than that. That's the way it is federally if you're using marijuana. And a lot of people know this already. And I'm sorry if I'm boring those people that understand. There's a lot of people who are listening to this show that don't understand that idea. That you don't have a right in Michigan to use marijuana under the Medical Marijuana Act as a right. It's not a right. And you're not granted permission under the law to do it. In fact, the law expressly prohibits it. The Medical Marijuana Act only carves out a shield, a protection. If you can stand entirely behind that shield, when people shoot at you, the shield will protect you. In most cases, the courts have made that shield small enough that you can't fit entirely behind it. And if they're going to hit you with, the gunfire that's coming, I'm just making an analogy, the gunfire that's coming from the criminal justice system, if they're going to hit you, I mean, they don't have to hit all of you. They just hit part of you and you're done. You're not all the way covered up. They're going to hit you. The shield is too small. So the Supreme Court today's ruling in Michigan had to do with the Hartwick-Tuttle case. These are two separate cases that they tied together and argued because they're very similar. And they argued them in order to make them tied together and bring them along the system in that way to the Supreme Court through the different hurdles you got to get there, the rulings with the Court of Appeals, et cetera. They have to be very similar in nature. They have to make the same underlying claim. And then the court has to agree that they're close enough together. They tie them together. And that's why you get this case called Hartwick-Tuttle. Or that's how it's commonly referred to. And the argument in these cases, David Radoy, the attorney who argued this case before the Supreme Court earlier this year, or was it late last? I think it was early this year. It was filed, previous to that, but I think they heard the oral arguments, if I'm not mistaken, if memory serves, early this spring. Is going to be on the show, and maybe he can help guide us through. I'm sure he can help guide us through what these individual cases, Hartwick and Tuttle, meant, because they had to do with Section 4 and Section 8 affirmative defenses. And the court ruled today, I'll reveal to you, that they unanimously, this means all the judges agreed on the panel, that they will affirm and what's the other one? Not affirm. They will affirm and, oh, good Lord. I can't think of the other term. Part of it's affirmed and part of it's overturned, basically, in each case. So part of Hartwick is affirmed and part of it is overturned. And then part of, I'm going to get rid of the Facebook thing. Now that's going to drive me insane. Part of Tuttle is affirmed by the Supreme Court and a part of it also overturned. Now, I think when I start talking to David here after the break, because it's coming up very quickly here, we'll get into this idea of what David and I were discussing on the phone earlier today when I said, hey, I think this might come down this week because the court, their last day in session is Friday. So I talked to David this morning saying, hey, heads up to the Supreme Court. It might, keep your eye out. And sure enough, this afternoon, sometime around, 1:45 or so, I saw the Post, Supreme Court decision. He called it the bubble bursting. If only part of what you're allowed to get under Section 8 or Section 4 is shot down, does it automatically shoot down all of the rest of the protections that you can assert under different claims? The Supreme Court today said that bubble doesn't burst. Your protection doesn't go away. We'll find out more next.
You're getting the full melt.
Got something to hide? Canalock offers discreet and effective storage solutions that destroy odor, so nobody knows. Canalock is a patented charcoal-activated bag that discreetly stores your marijuana. Canalock is made from the same material as military chemical warfare suits. Get yours at canalock.com. Visit canalock.com to learn more about no-smell technology.
Hey, it's Steve Green for the Sweet Leaf in Flint, because now getting safe access to medical cannabis patients in Flint, Michigan is never more welcoming. Presenting the Sweet Leaf, a brand new patient experience bringing 12 carefully selected caregivers housed in 9 separate offices to distinctly assist you with their knowledge and reputation for excellent patient care. Classes and training coming soon in the large community room. Check it out in person, 400 South Door Highway, or call 810-259-2571. The Sweet Leaf Center in Flint, 810-259-2571.
Get growing with GrowMax. Indoor, outdoor, beginner, or a warehouse full of Gavitas. Probiotic organics, or huge production with Max Power Monster Aeroponics systems. We can help you rock it. YouTube GrowMax with 2 X's. Customer service is why we're blowing up. And I'm Dave. My cell number is 906-221-2111. We also specialize in electrical and HVAC and new double-ended bulb technology. 906-221-2111. Get growing. GrowMax.
Get the beach bong ready for sunshine and sandy beaches in McGrill, Jamaica this November as the High Times Cannabis Cup moves from Amsterdam to the Caribbean. Your trip starts with the absolute best rates on airfare, hotel, events, and all your Cannabis Cup travel needs at travelcannabiscup.com. Come stay with us, relax in the sun, play in the sand, and smoke down with the cool people, man. Get to the High Times Jamaica Cannabis Cup. Best travel prices right now at travelcannabiscup.com.
It's the Full Melt Radio Show. So the thing that happened today was a Supreme Court decision in Michigan on the Hartwick Tuttle case. So we're going to welcome to the phone lines, the Canalock No Smell Bags phone lines at canalock.com. Attorney David Radoy. David, welcome to the program.
Hey, Steve. Happy to be here.
Were you surprised that the decision came down today? Because I knew that it had to happen this week. Yeah, can you hear me? Can you hear me? Oh, I'm sorry. I turned you down. I turned something down. Maybe you lost my voice. Can you hear me, David?
Yeah, I can hear you now.
Sorry about that. I was trying to turn down the music so that you could hear me over the music, but I did something wrong. So listen, were you surprised, I was going to ask you, that the ruling came down today? Because this morning I knew it was going to happen this week, but I figured it might be Tuesday or Thursday or maybe even Friday before they actually did it. Were you surprised that the Supreme Court made this decision today or released the opinion?
I guess I was a little bit surprised. Actually, I was informed by you, Steve. So, yeah, I was a little bit surprised. I thought they would wait till the absolute last second.
I did too.
Every indication has been that they are doing that. But no, it came out today. It is a very lengthy opinion. I have not even close to finished digesting it yet. I'm
right.
on my second read now.
Now, you argued this case before the court,
I did not.
You did not?
I argued the People v. Mazer case, which was argued at the same time.
I got you. So there's the confusion.
I tried to do my best to argue these cases too, when possible during my time that I had to argue to the Supreme Court. I tried to get into some of the mutual factors between our cases.
Right.
Like the whole bursting bubble idea. I tried to, that applied to my case as well, even though it wasn't one of the questions they were asking me to argue about.
Describe that bursting bubble theory so that people understand when we use that term what it means.
Okay, so in the case of People v. Tuttle specifically, there's evidence that Tuttle sold marijuana to somebody he was not connected to through the act.
Right.
So that would be an act, if true, this is all allegedly, but if that's true, that would be something that's outside of Section 4.
Right.
And what the trial court and then the Court of Appeals held is that if you violate Section 4 anywhere, you get it nowhere, basically. It's a bursting bubble. So you have immunity, but as soon as they have some evidence of a violation of Section 4, even as to a totally different offense than the one that you're asserting it for,
right.
They say that bubble basically bursts. You have no immunity.
All protection goes away. It's all blown away by the wind.
Just to explain that further, let's say you're charged with 3 crimes for growing marijuana inside your house, and then 1 crime for delivering marijuana to somebody, and basically, even though you would still satisfy all the elements to protect yourself from prosecution for the plants in your house, you wouldn't get that immunity because of the sale and a totally different crime that took place outside of your house.
David, go ahead. I didn't mean to interrupt. Go ahead.
Yeah, and all I was going to say is basically that's a really bad ruling because it means that committing some crime that's unconnected would make you lose your immunity and basically lose your defense for everything that was going on somewhere else. So that was a very scary ruling for us medical marijuana attorneys because it was going to give courts and prosecutors really a way to screw patients.
So basically, if they got one little bite of the apple, they got to eat the whole apple.
Yep, pretty much.
And this ruling kind of changes that. It says that if you got one little bite of the apple, the rest of the apple remains.
Exactly. What they basically set out in this ruling, and again,
It's still being
I have
digested.
not had a chance. I worked pretty late today, so I'm on my second read through, so I don't have a full my full analysis done of this case yet.
Right.
But what is very clear is that the Supreme Court intends for each crime to be separately analyzed. So there's no bursting bubble of immunity. Each crime, for each separate crime, you have to look at the elements of Section 4 or Section 8 completely separately and make a distinction, or the court needs to basically rule on these factors in some manner. And we'll talk about the burdens that the court sets out here later. But each crime is separate. Now, what they still do leave open is that if there is a connection, that it could still possibly burst the bubble, rebutting the presumption of medical use, for example.
I think the opinion used the term nexus, so a connection between.
Yep. Sorry, lawyer word there.
Right.
But a connection between. So let's just say, and this is what I fear is going to end up getting argued all the time, is just like for Tuttle, where there's that outside sale.
Right.
Well, if they can prove that outside sale came from marijuana that was manufactured inside the home, well, maybe they can use that as evidence to defeat the Section 4, because one of the elements they say you have to prove for Section 4 is that it was only intended for medical use.
Right.
And so they could use it to defeat that by saying, no, this was what you sold to this guy outside of the house. I think they'd have to at least present some proof of that connection. But it's still, it's much better than what the previous court rulings were, is that they don't even have to show anything. As soon as you show one violation of Section 4, you've lost it, completely.
David, do you know who argued this case before the Supreme Court? Because I assumed that it was you, but I confused it with Mazur.
Yes, I know both of the attorneys. I'm sorry, you'll have to.
That's okay. I put you on the spot. I didn't. You know who they are, but it's
Jim
hard to
Miller,
reference.
And then the other attorney is. Oh my God, I'm going to die that I forgot his name.
That's okay.
He's
That's
also
okay.
a magistrate in Clarkston.
It's okay. I didn't mean to put you. On the
we'll
spot.
say this: there was two attorneys that one of them is actually a court-appointed attorney.
Wow. Well, I just badmouthed court-appointed attorneys. I did it to open the show.
I would say that he's a pretty good court-appointed attorney. I don't think most court-appointed attorneys are appealing cases all the way up like this. So,
No. So kudos to this man.
And the other one, neither of them are kind of known as like medical marijuana gurus, although they might be working their way there now. Once you make it all the way to the Supreme Court arguing comprehensive cases like this, you could say that they know it pretty well. But yeah, they're not. Neither are kind of the known medical marijuana attorneys for Southeast Michigan. They did it. I think they did a good job in both of their cases, and I think the Supreme Court already had a lot of these ideas about what the trial courts and Court of Appeals were doing, being like crazy.
Right.
This opinion in my, this is my analysis, is this opinion is pretty reasonable. It's not as good as I would have hoped for. But it's definitely, it definitely reverses the really negative aspects of the rulings from the Court of Appeals and trial court. They overrule the really bad stuff.
Well, that's refreshing.
In my opinion, I think they really thought this out, the Supreme Court. And
it was a unanimous decision, right?
Huh?
It was a unanimous decision, right?
Correct. Yep. Unanimous decision, and it seems like they really did, all the time that they took to release this,
right?
That they really did take advantage of it. In my opinion, it's very well reasoned. They really back up a lot of their assertions by citing other case law, and generally it makes a lot of sense. I don't agree with them always, but this current panel of the Michigan Supreme Court, I'm feeling pretty good about so far. The Mazur case, I wish it could have gone a little better. This case, I wish it could have gone a little bit better, but generally they at least brought some sanity back. This case is definitely going to increase the chances of winning a lot of these defenses compared to where we were before.
David, let me invite the audience at large into this conversation, if you wouldn't mind. 844-420-TALK. It's a toll-free number, 844-420-TALK, if you want to call and discuss today's opinion. Maybe you have a question. You can bounce it off of an attorney. The Cadillac phone line number 1. Hello, you're on the air. Hello?
Is that me?
It is indeed.
This is Neil Rockine. You told me to call in.
Hey, Neil, how are you?
Good.
What's up,
How are
Neil?
you? What's up, buddy? How are you?
Doing good. Just digesting the opinion still.
Good.
So, Neil, what do you have to say about this ruling today? Can you shine some light on this for us? What's your opinion?
I don't think it's great. I think. Well, listen. I'm going to take the word I think of it. I expected more out of 2 or 3 justices on the Supreme Court than what we got in this ruling. You know, they devoted a lot of time to Section 4. Quite candidly, in court, we just don't see a lot of Section 4 cases. For the most part, at least what I see and what I handle are, I think, hairier, messier cases where there are arguably Section 8 defenses, and we've been looking for a real change of background and scenery as to how these cases are supposed to be argued, with the concept being that the initiative said that anybody in a marijuana case should be able to advance a medical purpose defense. That was in the initiative. That was the 4th prong in the initiative. Right. It was the one that I particularly was supportive of, because I understood that at least in my mind, I thought, look, anybody that has a marijuana case is going to be able to get in front of a jury and be able to argue that they had a medical purpose. The jury can, of course, flatly reject, some guy sitting around, his back porch with his buddies doing high fives and cartwheels, and he's got, in perfect health, who's an Olympian with no medical issue at all to speak of, and the jury could say we don't find the medical purpose in that case. That's kind of that's what I thought the law was going to allow us to do in these marijuana cases.
Didn't it seem that way, Neil, by plain language of the act? It seemed that way to me.
Well, I think that what happens is there's an old saying. The answer is yes. I'll say yes. But I think there's an old saying about editors, and that whether a paper needs editing or not, if you submit something to an editor, it's going to get redlined.
Right.
There are old stories about how dock workers and steel workers in New York would add imperfections to their work deliberately, so that when the inspectors came, the inspectors would find the deliberate errors and order that those be fixed, because they realized if they made something too perfect, they would still want them to correct, just to validate their existence. And I feel like the courts in this way have really taken something that isn't that complicated and have made it extremely complicated. The idea of a bona fide physician-patient relationship was not meant to be something where we had to actually, you needed to bring a body cam with you and vet the doctor. It was really meant to avoid someone walking into a doctor that they had never met and just saying, "Oh, I've got a tumor. Okay, here's here's some here's a certification to use marijuana." It was meant to be something more. And how much more was really something that I always thought would be open for debate in the courts, not a bright line. And unfortunately, the way I read this opinion, the opinion treats Section 8 like a redheaded stepchild.
It does.
And it says, when you look, and anybody that's been in the courts like David has, and certainly David and I have had a number of cases together, and David's a young warrior, and he knows, but you read it, and the prologue for Section 8 is, well, it's supposed to be harder, it's supposed to be onerous, it's supposed to be more challenging than Section 4, except, where was that written? Where was that written anywhere that it was supposed to be more challenging or more onerous? I don't know. They decided that on their own. So,
well, I would just say that the only thing is that Section 4 does have a presumption. So that on that level, at least one element you can prove with, is presumed, where Section 8 doesn't have.
But Section 8 has a presumption as well. The presumption in Section 8, if you read it, is actually, remember, you are presumed to be engaged in the medical purpose of marijuana if the following three conditions are that defense is presumed valid, is the language in Section 8.
Yeah, I guess my point would just be that Section 4 is a little simpler just in the plain reading, but I agree with you. I mean, it's not Section 8 is not supposed to be hard. That's the whole California Medical Marijuana Act.
So, unfortunately, when I read through, Section 8, or at least the analysis of Section 8, I do. There are parts of it that improve the analysis, but there are parts of it that are terrible. So primary caregivers must establish the amount of usable marijuana needed to treat their patients' debilitating medical conditions, and then how many marijuana plants the primary caregiver needs to grow in order to ensure uninterrupted availability for the caregiver's patients. Is there any farmer in the history of farming that's ever had to identify the number of successful crop, plants that you're going to grow in order to produce a particular yield? I mean, it's almost impossible. It's very difficult to tell. Yeah,
but the key, I don't think it's that bad because it's still reasonable. What they took away was the really horrible part that you had to know what dosage the doctor recommended, which was insane. I
agree with
so
that.
At least they got rid of the really bad stuff from.
I think to the extent that they eliminated the connection between the patient or the caregiver and the doctor, I agree with you. I think, to be candid, I think my view is that they could have made Section 8 a shot. They could have left Section 8. They could have changed or reversed the terrible parts of Hardwick and Tuttle that came out of the Oakland County trial court.
Listen, fellas, we're hitting the commercial break, and I know it's going to be difficult for you to hear me over the music because of just the way it works out. Can you hang on through the commercial break for a second with us?
I can hang on for a minute, sir.
Yeah, I can hang on as well.
Thank you so much. All right, hang on. We'll come back and talk more about what this opinion today means, how it relates to you, especially if maybe you've got a case before the court. We'll talk about that coming up next. Please don't go away.
You're getting the full melt.
Get growing with GrowMax. Indoor, outdoor, beginner, or a warehouse full of Gavitas. Probiotic organics, or huge production with Max Power monster aeroponics systems. We can help you rock it. YouTube GrowMax with 2 X's. Customer service is why we're blowing up. And I'm Dave. My cell number is 906-221-2111. We also specialize in electrical and HVAC and new double-ended bulb technology. 906-221-2111. Get growing. GrowMax.
If you're like us, your pets aren't just animals. They're members of your family. Pet Pain CBD hemp oil drops are great for aging as well as active dogs and cats. Some people are apprehensive about hemp treatments for pets. They ask us, what are you smoking? Absolutely nothing, and neither will your pet. Like other hemp-based products for humans, the allure is all of the benefits of cannabis without any of the high. The CBD oil has shown to rejuvenate the bones, joints, brain, stomach, eyes, and heart. And the drops contain absolutely no corn, wheat, soy, artificial colors and flavors, or preservatives. Pick some up today. Visit petpain.com or ask for Pet Pain at your local pet store. Petpain.com. CBD relief for your pet.
It's not easy out there, but it can be easier. And when it comes to medical marijuana in Michigan and chronic pain management, Dr. Bob Townsend, renowned for his patient advocacy and deep understanding of how patients and medical marijuana certifications fit together, makes it his hallmark to educate and provide the best holistic treatment for your condition. His knowledgeable staff makes you feel warm and welcome, and Dr. Bob makes you feel well. With locations across the state in Cadillac and Gaylord, Kalamazoo, Marquette, Mount Pleasant, Muskegon, Saginaw, Traverse City, you can't beat the convenience and feeling you get knowing you have someone on your side that cares. Denali Healthcare is on the web at denalihealthcaremi.com. Get answers to your holistic health questions or schedule an appointment now by calling 989-339-4464. Chronic pain management and holistic health answers is what they do. It's all they do. DenaliHealthcareMI.com. Get your certification and peace of mind now by making an appointment with Dr. Bob Townsend at 989-339-4464.
Get the beach bong ready for sunshine and sandy beaches in McGrill, Jamaica this November as the High Times Cannabis Cup moves from Amsterdam to the Caribbean. Your trip starts with the absolute best rates on airfare, hotel, events, and all your Cannabis Cup travel needs at TravelCannabisCup.com. Come stay with us, relax in the sun, play in the sand, and smoke down with the cool people, man. Get to the High Times Jamaica Cannabis Cup. Best travel prices right now at TravelCannabisCup.com.
It's the Full Melt radio show. Fascinating ruling by the Michigan Supreme Court today on the Hartwick-Tuttle case and your protection under the Medical Marijuana Act as far as what kind of protection do you get. I mean, that's all that the act does is it gives you protection. It gives you a limited immunity. We've been talking on the phone with attorneys David Rudoy and Neil Rockine. Guys, you were talking about when we hit the commercial break, and I'm sorry to interrupt the conversation. We were talking about plant count and how, how these this ruling affected, what patients and caregivers have to be aware of. What's the What's the takeaway? Go ahead.
All right, so I have to go in a second because I'm going to join my wife for dinner. But let me add. But let me. The lawyer's name that argued the case on behalf of Hartwick was a guy named Fred Miller, who really deserves a lot of kudos because he's a court-appointed lawyer, as David said, who didn't really get paid to continue the case. He just continued the fight.
Thank you for him.
On behalf of Hartwick. This is the part of what I thought the Supreme Court did, which was, in my opinion, very cowardly, was unfortunately try to wrap itself around its strict interpretation language and the limits that its limits on how it could interpret this act. If you read footnote 79, it really says it all. Because possession, manufacture, and delivery of marijuana remain punishable offenses under Michigan law, the caregiver defendant's patient might be unwilling to testify to the patient's marijuana-related activities due to fear of criminal prosecution. This would present a significant barrier to the caregiver's ability to establish a defense under Section 8. And because a witness cannot be compelled to give testimony that the witness reasonably believes could be used against him or her, a patient's justified refusal to cooperate might prove fatal to the primary caregiver's Section 8 defense. While this may seem a harsh consequence, this court has no power to alter the statutory language. To me, that's complete and utter nonsense and bullshit.
Yeah, and that's very similar to their problem in the Mazur ruling as well in my case, which was they said a similar thing. Like, we recognize this is totally unfair that she should lose her immunity because of her husband's conduct, but we have to read it that way. There's no other way to read it,
Seems to me that the Supreme Court is free to read a statute any way it chooses to read it, including to add some sense to it. And so that footnote, to me, says it all. So if you're a caregiver and you take on the responsibility to grow plants or to cultivate marijuana for a patient, and that you get raided or prosecuted, and you have to assert a Section 8 defense for whatever reason, not a Section 4 defense, but a Section 8 defense, and you come to court, and you just want your patient to come to court and to say that, hey, my man, he's a caregiver, he does a great job, he checks in with me all the time, I use marijuana for medicinal purposes. If that patient decides not to do that, that could prove fatal to the caregiver's defense, and the caregiver says, too bad.
Because
I think what you said online earlier, Neil, is really good advice, which is because you can never be sure if they're really going to come testify for you. But
correct.
You can start building your evidence of Section 8 without their testimony.
Let me ask. I've got a really good question.
That's going to be my next focus, is to advise people who, and the inevitability that you may need a Section 8 defense. It's to get, if you're a caregiver, get your patients on board. Every time you give them marijuana, you need to have them sign something saying that they had a bona fide doctor-patient relationship. They're using to treat a condition. The amounts they use are reasonable. Have them fill in the amount. You know what I mean?
Make this a business record, like Neil's saying.
Correct.
Do it every time.
Absolutely.
You guys, could you, in a sense, make a civil contract as a caregiver with a patient that says that you must come to testify if I have to raise an affirmative defense on your behalf?
No.
You can't force them to.
Wow.
And if they don't, what's your remedy? Right. What are you going to sue them? I mean, the better thing is
Amendment right that would anything.
The best practices approach is going to be to, instead of having to go into the woods to try to find some wood and kindling and flint and some string and wood and a way to start a flame, the better approach is just to insulate yourself from the start. So, the way to insulate yourself before it gets cold, in other words, before the trouble may come, is to paper yourself, make a paper trail, create a paper trail. And I think, I'm going to sit down. My plan is to sit down with some people, David certainly included, but, Mike Camorn and others, and try to figure out a way to give people some advice on what to do. Maybe we'll hold a seminar or do a conference or do a call-in or something. So
I want to see that form on LegalZoom. That's what I want to see.
So we're going to see. Anyway, listen, guys. You guys are wonderful company, but you're not as good a company as
your lovely wife,
as Karen Rockine. So I'm going to leave the two of you, and I'm going to go join her. And I wish all your listeners a great evening. So be careful out there.
Thank you for helping us.
Talk to you soon. You got it.
Have a good night, Neil.
Bye, guys.
All right, bye, Neil. Thank you, David. That I guess where we're at, where we've left off in this conversation before Neil left us is, I want to watch out for the patients and caregivers. I mean, that was what this whole thing was about, right?
Definitely. And, I mean, Neil's right that this opinion could have been a lot better, okay? I agree with him about that, and I think that there's some really negative aspects of this opinion. But generally, this opinion, compared to what was the law based on the Court of Appeals opinion in these same cases, is astronomically better. I mean, this went from you have no chance of winning a Section 8, if you're a caregiver at least, to you can win it now. I mean,
there's a pathway to success.
And Section 4 as well, it saves a lot of people because there are a lot of situations, like Neil was talking about, we don't litigate Section 4s that often. And there's a reason for that. It's because usually there was some act that was out of conformity with Section 4, which meant that the judges were precluding us from asserting Section 4 at all.
So wait, now what this means now, if I'm not mistaken, if I'm picking up what you're putting down, is that there will be a lot more Section 4 hearings now.
I think so, because now, even if there was a sale
that wasn't compliant,
or there was, some aspect of the case, like, for example, like the marijuana plants were not kept in a locked and enclosed facility, that doesn't mean that your possession of the marijuana that they're charging you with possessing usable marijuana with intent to deliver, that doesn't mean that you don't still have a Section 4 defense as to that possession just because you lose your Section 4 defense as to the plant.
So let me describe.
It opens it up for a lot more Section 4 litigation.
Let me describe a situation. So you got 4 charges, whatever they are, various and sundry charges. One of them is out of compliance with the Medical Marijuana Act. The other ones are in compliance. Currently, before today's ruling, under the Court of Appeals decision previous to this case, you would have lost it because the one crime was deemed to be out of compliance. You lost your protection for all crimes, and you'd be convicted potentially of all of them if you took it to trial, or you'd have to find another way around those hurdles. But now that this court ruling has happened, they could only, let's say 3 of them were in compliance, one of them was not. as far as asserting Section 4, that you've got some assumptions under, you're assumed to be doing certain things under Section 4, they could only really convict you of the single crime, and the other three would go away.
Yes. As long as barring that they can't prove a connection.
A nexus.
Between the crime where you are out of compliance and the crimes where you are in compliance.
There can't be an umbilical, in other words. Let's see, I'm just trying to find a scenario where that umbilical would exist. Could you think of one, David?
Well, I think I stated it earlier, but if you sold marijuana to somebody, and they're charging you, let's say, with two different crimes. One for manufacturing marijuana for the plants inside your home, and one for delivery of marijuana to somebody outside of the home. Okay, you went and delivered to an undercover cop.
Right.
And so he didn't have a card, and it wasn't in compliance. Well, previously you were screwed on the plants inside your house. Now you're not screwed, but the prosecution can bring in evidence that marijuana that you sold to that officer was from the plants in your house, and so it still could be used to defeat your Section 4, but it's not automatically defeated.
Wow.
So let's say they had some sort of expert who could analyze the strain and phenotype, and they could bring in evidence that says this marijuana came from these plants inside this house. I think that would be difficult for them to do, but if they could do that, and then they would show a connection between the manufacturing and the delivery to the officer, then yeah, you could lose on both cases still.
Admittedly, it would be difficult for them to prove, were it not for your own testimony, that the marijuana that you delivered actually came from the grow.
I think it would be very difficult for them to prove that.
Because it's beyond a reasonable doubt there.
Well, that is not true.
Preponderance.
What the court, this is an interesting aspect of this opinion. The court proved that, or the court stated that we have to prove that the defendant, when I say we, I will always mean defendant.
Right.
That we have to prove that with a preponderance of the evidence. So they can bring in evidence, and if we still have to prove each element with a preponderance of the evidence. So they can rebut element 4, which is that this was only intended for medical use, or presumption of medical use, but medical use. They can bring in evidence to rebut that, and the judge could find, nope, defendant did not prove with the preponderance of the evidence. Now, preponderance of the evidence is a much lower standard than beyond a reasonable doubt.
David, we're about to hit break again. Just heads up.
What's up?
We're about to hit break again. Just heads up to that. The music's
Okay.
about to start. Go ahead.
But yeah, I mean, it's still, there's a presumption, but it can be defeated. But the one negative aspect of this opinion is it's still left to the defendant. We have the burden of proving with the preponderance of the evidence, rather than what I was hoping for is that it's their burden to prove with the preponderance of the evidence that it's not Section 4 compliant.
Gotcha. Can you stand by us? Can you stand?
A huge difference.
Can you stand by for a second again, David?
Sure.
All right, hang on. More on the Michigan Supreme Court decision coming up after the break.
You're getting the full melt.
Got something to hide? Canalock offers discreet and effective storage solutions that destroy odor, so nobody knows. Canalock is a patented charcoal-activated bag that discreetly stores your marijuana. Canalock is made from the same material as military chemical warfare suits. Get yours at canalock.com. Visit canalock.com to learn more about no-smell technology.
Imagine a world where patients can use marijuana like any other medicine. The Marijuana Patients Organization challenges the status quo by helping our neighbors to enjoy a better quality of life. Visit the MPO at marijuanapatients.org and enjoy informative articles, engaging debates, and information about treatments, doctors, and dispensaries in your area. Over 50,000 people have registered at marijuanapatients.org since 2010. Join us at the Marijuana Patients Organization today, marijuanapatients.org.
Hey, it's Steve Green for the Sweet Leaf in Flint, because now getting safe access to medical cannabis patients in Flint, Michigan is never more welcoming. Presenting the Sweet Leaf, a brand new patient experience bringing 12 carefully selected caregivers housed in 9 separate offices to distinctly assist you with their knowledge and reputation for excellent patient care. Classes and training coming soon in the large community room. Check it out in person, 400 South Door Highway, or call 810-259 259-2571. The Sweet Leaf Center in Flint, 810-259-2571.
If you're like us, your pets aren't just animals. They're members of your family. Pet Pain CBD Hemp Oil Drops are great for aging as well as active dogs and cats. Some people are apprehensive about hemp treatments for pets. They ask us, what are you smoking? Absolutely nothing, and neither will your pet. Like other hemp-based products for humans, the allure is all of the benefits of cannabis without any of the high. The CBD oil has shown to rejuvenate the bones, joints, brain, stomach, eyes, and heart. And the drops contain absolutely no corn, wheat, soy, artificial colors and flavors, or preservatives. Pick some up today. Visit petpain.com or ask for Pet Pain at your local pet store. Petpain.com. CBD relief for your pet.
It's the Full Melt Radio Show. You can reach us here Monday through Friday from 7 until 8 p.m. Eastern Standard Time. Really easy to subscribe to us. If you can't listen live, go to thefullmelt.com, find the iTunes link, and subscribe there. Just click the link, and there you go. We're talking to attorney David Radoy. Thanks for coming on the program, David. I've got a caller calling in. Canalock No Smell Bags line number 1. Hello, you're on the air. Hello?
Hello.
What's your name, please?
David.
David. And David, where are you calling from?
94 right now in Harrison Township.
Okay.
I'm calling in a little late. I missed a lot of what you guys were talking about today, but is there any possibility that you guys can summarize, or David can summarize the ruling that came out today, like a brief synopsis? I tried reading 5 pages of it, and it was pretty crazy.
Can you give it a rundown real quick, David, for him?
Yeah, I think so. I mean, to be clear, this is a 52-page opinion from front to back, so I can't give a full synopsis. But just to kind of quickly go over it, the really negative stuff that came out of Hartwick and Tuttle in the Court of Appeals, the Supreme Court did away with. For example, the idea that the caregiver needs to know how much marijuana the doctor recommended to the patient, that's gone. So the court said instead, a primary caregiver may reasonably rely on the amount his or her patient states is needed to treat the patient's debilitating medical condition. So you have to have the conversation with your patient about what they need, but you don't have to know what the doctor recommended, since doctors don't recommend dosage anyways, and that was a really retarded part of the Court of Appeals ruling. So a lot of the really negative stuff, also this major idea, and this is something really important, is that if you lose your Section 4 immunity as to one charge, let's say there's multiple different charges, and on one charge you lose your Section 4 immunity, let's say your door wasn't locked to the basement where the plants were kept, that doesn't mean that you lose your Section 4 immunity to every single charge, which is pretty much how courts have been ruling since the Act came out. So that was a really positive step made by the Supreme Court. Overall, there's a lot of aspects to this case, a whole bunch, and I could talk probably for hours about it already, and I haven't done a second reading. But generally, the idea is the Supreme Court restored sanity to the Section 8. They didn't make it super easy. They didn't go as far as they could have on a lot of aspects of this. Based on reading the language of the ballot initiative and what the intent was, I think they should have gone a bit further. But Section 8s and Section 4s are much more winnable. I mean, Section 8s went from unwinnable before to very winnable now. They're still hard. They still made it pretty tough to prove your elements.
And it still could be costly.
And it's still very costly. But we've restored some sanity. I mean, basically under Hartwick and Tuttle, they were asking for things that are impossible to provide, like for the caregiver to know the dosage recommended by a doctor when doctors don't recommend dosage. Stuff like that. They really got rid of the bullshit the Court of Appeals is trying to peddle.
Now,
so they're keying on the fact that they want you to know what the conditions were that they're trying to treat. Is that what I'm hearing?
Yeah, we're done with that. I mean, you should know as a caregiver, you should probably know your patient's condition and how much marijuana your patient tells you he reasonably needs. So you should have some idea of what your patients use. But that's it. You have to rely. You don't have to get in between the patient and his doctor.
Right.
You can rely on your patient telling you, this is how much marijuana I need to treat my physician. That's a huge thing that the Supreme Court fixed here, and was something that courts across the state were holding people to need when, in fact, doctors could lose their controlled substance license for actually recommending a dosage of marijuana.
Right.
So doctors don't do it. So it essentially meant that all Section 8s across the state for caregivers were going to lose under the old ruling. So they fixed a lot of the problems.
Okay, so now listen. There was something in this ruling that still remains with regards to the caregiver needing to know how many plants they would need to grow, isn't there? I read this. It seems that
there is, but it's about reasonableness. So basically, I don't view it as that bad, to be honest with you, because the words reasonable are used.
Would you consider the 12 plants that are allowed under the Act reasonable?
Yes, but the Section 4 has no longer, they made this very clear. 12 plants, 2.5 ounces, when you're analyzing the Section 8 affirmative defense, don't mean anything. Now the caregiver has to say, this is, my 72 plants were reasonable because per plant, I harvest, let's say, 12 plants per month, or I'm just kind of making up numbers here, but let's just say I harvest 12 plants every month. Each plant has 2 ounces on it, so that's 24 ounces a month, and I have 5 patients that require, or I have 5 patients plus myself, and we each require a quarter, 4 ounces per month. That adds up to 24 ounces. That's why I believe my amount of marijuana is reasonable to provide for my patients. I mean, that's all you really have to do is be able to explain it, and a good medical marijuana attorney already knows how to do that well. I mean, it still puts the burden on you, and it's not as good as it could have been, but at least it's just, you just base it off what your patients actually use. I think it restored a lot of sanity to the whole idea.
So Neil spoke to the idea of insulate yourself from the beginning so that you don't have to have the encounter. Wouldn't you say that it would be reasonable to then practice this in your own head every time you acquire a patient as a caregiver, to go through the motions of understanding what it is that you'll have to articulate to the court in the event of a Section 8 defense?
100%. I mean, that's something that I think Neil and I have already been doing, previous to this.
Right.
But now this ruling made it very clear that, if your patient won't show up for you, you still have to fulfill the elements of Section 8. So there are ways to start building the defense. So in the case where your patient, let's say your patient dies or for whatever reason can't come testify for you or won't come testify for you, you need to still have something to bring to court to say, I was giving it to this person, this person, and Neil put something online earlier today, which I think is a really good idea, which is you need to be having your patients sign stuff that you keep. These documents need to be kept in the normal course of business because you need to think about how the evidence can actually get in with the rules of evidence. And I would definitely recommend all the caregivers out there, all the people, all the providers of marijuana, to consult an attorney because there are ways to protect yourself with this current landscape. This case made it where you can win these cases again, but still it requires a lot of advice, more than I could give on the radio here.
Right, for sure. David, if people wanted to call you and get advice from you, how can they get a hold of you?
I can always be contacted on my cell phone, 248-935-9074. Don't have a wife or kids, so I take calls 24/7. Also, you can go to my website, rudoylaw.com. That's RUDOILAW.com, and all my contact information is up there.
Oh, we lost our caller. Sorry about that.
No problem.
Repeat that last part again because I think the your call has ended over blurted you.
I was just saying my website, RUDOILAW.com. That's rudoylaw.com. You can go there anytime, and there's a contact form right at the top of the page, and it will pop up as well. And also my cell phone number is available on there, so I can be called anytime, 24/7.
I anticipate, David, that phone will be ringing now Because there's a lot of people that are going to have questions about this, and given the new landscape and new methods of preparation, which I think is very important. Look, if you're a guy that does you've got guns and you're going to duel it out with somebody, you can bet that before you get in front of that duel, where you got to try and get to shoot before the other guy shoots, you're going to practice and have some target practice so that you're good with your aim. That aim needs to be perfect when you need to use it. And I'm saying that this new landscape provides some direction as to how to insulate yourself and how to take that target practice before you have to actually go to court and do the shooting.
I think that's a good analogy. I like it. So, but I mean, it's really true. We've gotten from the Supreme Court, and I don't think they're going to be changing this ruling anytime soon. So we know what evidence that we need to be able to win your case.
David, thank you for coming on the program. We're at the end.
Okay.
We got more to talk about on another day, but thank you for joining us today and helping explain this ruling.
Thanks for having me, Steve, and thanks for
The Full Melt Show is a production of TFM Media.
Earlier possible.